We're so happy to have with us Michael J. Glennon, the professor of international law at Tufts University's Fletcher School for International Affairs. It's a pretty lengthy mouthful there for me. He is a true expert and frequent commentator on public affairs. He's previously taught at universities around the world, has appeared on Nightline, All Things Considered, elsewhere, and of course his work has been published in print in a variety of places, including the New York Times, the Washington Post, the Los Angeles Times, everywhere that you might expect to see it. His book that he is sharing with us tonight is National Security and Double Government. I'm going to let him tell you most about it, but it really takes you through sort of the post-World War II world all the way through today. It talks about some possible solutions and pitfalls to all the things we face in our ever-changing world. So I'll let him tell us more about that. But please join me in welcoming him to Politics and Prose.
Abby, thank you very much for inviting me to be here this evening, and thank you all for coming out on this balmy, by Boston standards, balmy Washington evening. I see a number of Fletcher students in the audience here. I teach at the Fletcher School of Law and Diplomacy at Tufts University, and I'm almost tempted to announce that this is a makeup class for them. You know, we've had a little snow in Boston recently, and I don't want to undercut Tufts' recruiting efforts. It hasn't been that bad, but it's nice to be back in warm Washington. Yes. I'm going to say a few words, brief words, about my book, National Security and Double Government, the thesis of which is that the curious continuity in American national security policy from the Bush to the Obama administration can be explained largely by the old 1867 theory of Walter Bagehot explaining the operation of the English Constitution. I'd like to do that by way of a kind of case study or example which illustrates what I'm going to be talking about, and that is something that you're all familiar with, the Senate torture report. I want to make three quick points in connection with the torture report. First, I want to suggest to you that the significance of that report lies more in what it doesn't say than in what it says. Second, I want to suggest to you that the deficiencies in the report trace largely to deficiencies in the structure of congressional oversight of national security activities. And third, I want to suggest to you that the deficiencies in the oversight structure can be explained largely, not entirely, but largely by Bagehot's theory. So let me begin first with the Senate torture report. We tortured some folks, President Obama said. And as you know, the Senate Intelligence Committee produced a multi-year, $40 million, 5,000-page study that focuses exclusively on the activities of the CIA and concludes, among other things, that torture was ineffectual in that it produced no actionable intelligence, and that the CIA misled the Senate Intelligence Committee, the White House, and the Justice Department concerning its effectiveness. That's, it seems to me, a curious focus for the Senate study for this reason. If we're honest with ourselves, it seems to me we've got to admit that it is at least possible that torture could have been effective. Whether it actually was effective is almost, therefore, beside the point and fortuitous or unfortuitous, depending upon your perspective. President Obama has said that's not who we are. If that's not who we are, why is the focus whether torture worked? The proposition is not we're for torture if it works. The proposition is we're against torture, period, I had thought. So it seems to me that the Senate Intelligence Committee, perhaps inadvertently, has wrongly shifted the focus of the entire national discourse by focusing on efficacy. So the more significant aspect of the report, again, it seems to me, lies in what it doesn't discuss, and that is legality and responsibility. One looks in vain through that entire report to find the slightest, thinnest discussion of the legality of any of the activities that are described in the report. It's rather amazing, but you go page after page after page, and the reader has to start wondering at some point, well, what about the international law, the Convention Against Torture? What about the customary international law prohibition against torture? What about the constitutional prohibition against cruel and unusual punishment? What about the multiple statutory problems, the Uniform Code of Military Justice, the Army Field Manual? There are a lot of very complicated questions that are raised about the legality of these activities, and none of them are answered. And some of them are quite important. I mean, you all know, I presume, about the infamous torture memos produced by the Office of Legal Counsel under John Yoo. Among the other questions that are raised by the torture memos are, number one, were those memos frivolous? Were any actual operators justified in relying upon those memos as a rationale for engaging in the activities in question? If they were justified, did they actually see the memos? Did they in fact rely upon those memos? If they did see the memos, did they limit their activities to the parameters outlined in the Justice Department's guidance in those memos? None of these questions are answered in the Senate torture report. So this is, again, just an amazing omission for an oversight committee, because one would think, I was, as I think Abby mentioned, the legal counsel of the Senate Foreign Relations Committee under Senator Frank Church. And when we did studies like this, and I'll mention this in a moment, you looked at the question whether the law was adequate. Were there holes in the law? Did those holes need to be filled? If so, what sorts of remedies or amendments are recommended? But you can't get to that point. You can't know what reforms, if any, are needed unless you know whether the current framework is working. And there's not even an effort to identify what the current framework is, let alone apply it. So that, it seems to me, is most unfortunate. And the upshot of all that is that the bottom line question, the most important question, some might suggest, doesn't get answered. And that question, of course, is who's responsible for this? Who is responsible for this? If some of these activities were in fact illegal, why hasn't anyone been prosecuted? Shouldn't someone be prosecuted? And if we don't know who was responsible in the past? How can we assess responsibility in the future to prevent this from happening again? So these are the questions that unfortunately are raised by what the committee does not say. And one is therefore left wondering why these issues are not addressed. And it strikes me that one plausible reason is that it might not have been in the committee's interest to shine a spotlight on its own record. Because as you read this report, the question that leaps out at you is, where was the Senate Intelligence Committee while all this was happening? I mean, it's supposed to be, we had thought, an oversight committee, present tense, not a hindsight committee, to prepare an after-action report and a historical record on what happened. It's supposed to be the eyes and ears of the Congress to act as a check on the abuse of power by the intelligence community. Where was the Senate Intelligence Committee? You know, there is a common belief that, as put by one of the principal commentators on this issue, everything in American intelligence is known to the congressional oversight committees. Nothing significant happens in the world of American intelligence without the congressional oversight committees knowing about that. That is simply not correct. The Senate Intelligence Committee did not know about the black site prisons that were established by the CIA where the waterboarding took place. The Senate Intelligence Committee didn't know that videotapes were made of that waterboarding. The Senate Intelligence Committee didn't know that those videotapes were destroyed. It didn't know about the surveillance of Chancellor Angela Merkel's telephone by the National Security Agency. When the Snowden leaks occurred, it didn't know what the bulk telephony metadata that was intercepted by NSA was being used for. The Senate Intelligence Committee did know that the harbors of Managua had been mined, but it didn't know that it knew that because the then chairman of the Senate Intelligence, Barry Goldwater, wasn't paying attention when the CIA told it that. And when he went to the Senate floor a few days later, having read about it on the front page of the New York Times, and complained that this represented an act of war, he was told by his staff that actually the CIA told us this, and he was somewhat embarrassed and surprised. He shouldn't have been surprised. Barry Goldwater had said earlier that he didn't even believe that there should be a Senate Intelligence Committee. And once it was established, he said he didn't believe that the Intelligence Committee should be told the things it was being told then by the CIA. Well, you know, Barry Goldwater is long gone, but his spirit lives on. Today, in the Senate Intelligence Committee, last year when James Clapper made false statements to the Congress about bulk surveillance in his answer to Senator Ron Wyden's question, the response that he said was the least untruthful, acknowledging that he spoke untruthfully to the committee. The committee did nothing. The committee indeed allowed that false statement to stand for months, as did President Obama, knowing that that statement was false before the Snowden leaks revealed it to have been false. When the CIA spied on the staff of the Senate Intelligence Committee, which the own Inspector General of the CIA said may well have been illegal, the Director of Central Intelligence, John Brennan, made false statements to the Council on Foreign Relations and the American people, denying it. But the Senate Intelligence Committee, knowing that it was true, did nothing. Of course, Mr. Brennan was later exonerated by an accountability board within the CIA that he appointed to determine whether he and his colleagues were guilty. Last year, the fact came out that at the very moment that Senator Frank Church said his prophetic words, if the NSA ever turns its awesome capabilities inward on the American people, we will cross an abyss from which there is no return and there will be no place to hide. When he said those words, he was being spied upon by NSA. His international telephone calls were being intercepted by the National Security Agency. You know, the torture report itself is based only on documents. 9,400 of the documents that the Senate Intelligence Committee requested in connection with that report were never transmitted. The CIA refused to give the committee 9,400 documents, and the committee dropped the request. The committee never issued any subpoenas. It never interviewed any witnesses in the CIA. It never sent any of its staff members to any of the black site prisons to see what was going on. I'll tell you, in my own experience with the Senate Foreign Relations Committee, admittedly a long time ago in the 1970s, admittedly under different leadership, it was standard operating procedure not to rely exclusively on documents that we would get from the executive departments and agencies. The committee was conducting, while I was its lawyer, investigation about the activities of foreign intelligence agencies in the United States. And we got thousands of pages of highly classified documents from the intelligence community, but everybody regarded that as a first step because those documents raise questions. They don't answer those questions. And you have to go to Langley and Fort Meade and the FBI headquarters and the State Department, as we did, and interview people to get answer to those questions. I interviewed dozens of officials at those agencies with a transcriber present to follow up on issues that the documentary evidence raised. Senate Intelligence Committee didn't interview, as I say, one witness, including the alleged victims. The lawyers for the victims came to the Senate Intelligence Committee and begged the committee to interview the witnesses to find out what had been done to them. And the committee didn't interview one of them. So that is the state of congressional oversight today. You know, the 9/11 Commission used one word to describe congressional oversight of the intelligence community in its report. The word was dysfunctional. Intelligence oversight was dysfunctional then, and it is dysfunctional today. John McCain, not exactly a bomb-throwing liberal, has said the intelligence committees have been co-opted. It is clear that they have been co-opted. And of course he spoke the truth. Who can seriously doubt that? So the question is, how could this have happened? How could this have happened? How could the equilibrium that was intended to derive from setting ambition against ambition have broken down so fully. The equilibrium that James Madison and the Founding Fathers believed was essential to, Justice Brandeis' words, protect the people from autocracy. How could that equilibrium have broken down? I think that the 1867 theory of Walter Bagehot, popularized, I might add, in the BBC TV show Yes Minister, provides something of an insight. Bagehot's theory, in a nutshell, was as follows. Bagehot aimed to explain the operation of the British Constitution, and he suggested that Britain had, in its governance, split into two sets of institutions. One, the so-called dignified institutions, the House of Lords and the monarchy, which he suggested the British people believed actually ran and managed the British government. But in fact, he suggested the government was run by an efficient set of institutions. The Prime Minister, the Cabinet, and to a lesser extent the House of Commons. And these efficient institutions operated behind the scenes. There were enough instances of the dignified institutions actually partaking in acts of governance to continue the illusion. But he said the bottom line was the British government was capable of evolving into a concealed republic behind the scenes as a result of the action of the efficient institutions. My suggestion in the book is that the United States government has also drifted into a structure of double government being Bagehot's phrase to describe this. The United States has unwittingly, without any nefarious conspiracy or dark intent, without any coup d'etat or anything of the sort, has drifted into a structure in which the Congress and the courts and the presidency have become, in the realm of national security, in effect, dignified institutions in the United States, and that the several hundred individuals, a network of managers within the intelligence community, the military establishment, the law enforcement community, have come to formulate and implement American national security policy, largely immune from electoral restraints and constitutional restraints. So Bagehot's theory, therefore, like any good theory, explains and it predicts. It explains why American national security policy has been so amazingly continuous from the Bush administration to the Obama administration. You know, in my book, the first 3 pages are a series of a couple dozen examples of what I'm talking about, but from drone strikes to national security surveillance to whistleblower prosecutions to the invocation of the state secrets privilege, the non-prosecution of torturers. The policies of the Obama administration in the realm of national security have changed very little from those of the Bush administration. And Bagehot's theory, as it dovetails with modern principles of organizational behavior, which it anticipated, suggests that that's entirely explicable, that the officials in these departments and agencies, the United States government, operate subject to very deeply embedded incentives within the political structure of the United States government, and that their objective, like that of officials in bureaucracies everywhere, is to advance their own careers. They do that by respecting the programs that their bosses established, not by questioning those programs. There's an inevitable tendency, therefore, to defend the status quo and continue existing programs. Those programs tend to be sticky down in economics terms, much easier to extend or rather than to terminate or to modify. And these individuals also have a preference for military solutions over diplomatic or political solutions, and they share the proclivities of people like Madeleine Albright for the reasons that so many Americans do. Madeleine Albright asked Colin Powell the famous question, why do we have this splendid military if we're not going to use it? Well, lots of Americans think that way. The American military is one of the most highly proficient and widely respected institutions in our country. And so when decision makers in the national security realm sit down at a table and there's a representative of the Joint Chiefs of Staff in uniform sitting at the table, there's a natural tendency to look to that person for a quick fix. And that happens over and over again in national security policy. So that's Bagehot's explanation. The prediction that the theory offers is one that exists in the short term as well as the long term. In the short term, the theory predicts that there is going to be no serious structural change made in response to the torture memos, in response to the Senate torture report, that the Snowden leaks are highly unlikely to lead to anything more than cosmetic tweaks in the existing legal structure. And in the long term, the theory unfortunately predicts that barring some sea change in what Justice David Souter referred to as the pervasive civic ignorance of the American people, which is the ultimate driver of double government. Barring some willingness on the part of the American people to achieve that level of civic virtue that James Madison and the Founding Fathers believed was necessary for this republic to operate, barring an ability to participate in government as informed and engaged citizen legislators, the likelihood is that the United States dignified institutions, the Congress, the presidency, and the courts, will continue on the same trajectory and end up ultimately as institutional museum pieces like the British House of Lords and monarchy. So that's the cheery news from snowy Boston, and I'd be glad to answer any questions.
We would love to take your questions. If you could just come to the microphone, ask them. Oh, could you just. It's just right there, sir.
Oh, yes. Good evening, Professor Glennon. I was very fortunate to study at the Fletcher School of Law and Diplomacy. Even more fortunate to study with Professor Glennon. I took his international law classes. Always very sharp, very engaging, It's always a joy to read you and listen to you. I think there is one actor, a very important actor in this dynamic that you don't mention in the book, and definitely not a virtuous actor that has definitely vested interests in this process. And I think it's the military and security industry, the private sector. How big do you think is the impact of this actor in the Trumanite-Madisonian interaction?
It's huge. And I plead guilty as charged. There's a huge literature on the military-industrial complex. And my objective was not to, in this little book, which is only 118, I think, pages long in the text, was not to canvass every potential cause or driver of this phenomenon of double government. A number of people have pointed out, probably correctly, that the great disparity in wealth in this country, the 99%, 1% split that we're all aware of, is also a factor. There are a lot of factors, I mean, but the overlap, Mario, is actually in the writings of a political scientist who wrote The Power Elite that a number of you have studied in college. His name was Mills, C. Wright Mills. And Mills was an influence on the thinking of a man that I suspect, I'd be willing to bet nobody in this audience has ever heard of, Malcolm Moose. Anybody heard of Malcolm Moose? Yes? Malcolm Moose was the president of the University of Minnesota when I went to law school there, and as fate would have it, he was the speechwriter of President Dwight Eisenhower, who wrote Eisenhower's famous farewell address warning of the emergence of a military-industrial complex. C. Wright Mills' writings seemed to have been heavily influenced by Bagehot's. So that's the confluence. But again, in answer to your question, I think you're quite right. I didn't go beyond the internal workings of the bureaucracy in describing these causative factors. And as I think you are aware, I wrote the original draft of this book based upon my own experience. I think you may have been one of the people who saw the original draft and commented on it, as a matter of fact, and then circulated it to a couple dozen people that I knew who included reporters from leading national newspapers, investigative reporters, officials in the CIA and FBI and State Department. And I simply asked him, is this an accurate portrayal of what I refer to as the Trumanite network, the network of managers of the national security apparatus? And to the last person, the answer was yes. And at that point, I proceeded to document what I and they knew from our own experience, to document it with public source material. And the public source material refers to the inner workings of the bureaucracy. It doesn't refer to Raytheon or Boeing or any of these outer influences or other private companies that undoubtedly have an influence, but they were just beyond the scope of the book. Thank you.
Thank
you. Yeah, this is kind of a two-part question, I guess. The first part has to do with sort of the underlying reason for Bagehot's theory or ideas, which I was not familiar with until I saw them in your book, and you spoke of them. It strikes me that one of the reasons why his idea may work and may work so well, not only in national security but presumably in all sorts of government and political issues and policy issues, is that the efficient institutions of government have a much better capability of dealing with an increasingly complex set of information and issues. Just the complexity, in other words, of the issues. That is the technical complexity. That the efficient institutions have the ability to deal with technical things, and have the upper hand, therefore, in any tug of war between the dignified institutions and the efficient institutions. So that from that we would think that the dignified institutions might like to have more control, but they aren't able to wrest it from the efficient institutions. And so the second part, the first part of the question is this complexity, technical complexity idea, do you think that is a substantial part of the reason for Blodgett's rule? And the second part of the question is, if it is true, in the case of, say, for example, moving from national security policy under George W. Bush to the Obama administration, was it true that the Obama administration wanted to wrest more control from the efficient institutions of government and was not able to? Or is it possible that in that case, and maybe in many other cases, the dignified, and again, I continue to use your terms here just for the simplicity of the idea, the dignified institutions have reason to not necessarily want to wrest control, that there are things that make it convenient and in their interest to leave a lot of details and a lot of controls over things like national security and other things up to the efficient institutions. So the second part of the question is, does it work kind of in both ways? Sometimes they want control and can't get it, and other times they really don't even want the control.
Boy, those are both great questions. Thank you for asking those. I appreciate that. The answer to the first question is yes. At one level, this is a technocracy problem. And we saw elements of the same phenomenon, for example, at the time of the economic collapse. The issues involved in rescuing the financial institutions of the Western world were so complex that the representatives of the dignified institutions, when they were confronted with this emergency, that they couldn't possibly understand because of its complexity in the short time frame within which they had to make a decision, had only to shrug their shoulders and defer to the technocratic experts within the bureaucracy. And increasingly, this is a challenge to our democracy. And we see this in a number of other areas. Global warming is one example. This is, again, at one level, an argument about what gets coded in one very complex computer model versus another. And laypersons are hardly in a position to assess which one of those computer models, and members of the dignified institutions, judges, senators, can barely assess which of those computer models is the valid one. They don't have time. They're supposed to be generalists. They're not technocrats. There is, however, one enormously important distinction between the technocratic institutions and the technocrats in the realm of national security versus those in economic and financial and environmental areas, and that is this. The Trumanite Network, the managers of the CIA, NSA, FBI, and Pentagon, do not set truck widths or speed limits on highways or determine the subsidies to be paid for windmills. They make decisions that can permanently and dramatically alter the fundamental legal and political contours of this society. And their activities require the greatest conceivable scrutiny. So it's especially discouraging to see oversight. We haven't talked about the courts at all. I'm certainly willing to do that if anybody's interested in it. Require the greatest possible scrutiny and cannot be deferred to as the expertise of the other technocrats can be. The answer to your second question is it's not entirely clear to what extent President Obama and his team pushed to exercise greater control over the national security community. It's very difficult for me to understand how a president can remain indifferent when the director of national intelligence makes a statement to the Senate Intelligence Committee that is flatly false, and that statement is made under oath. It's hard for me to see any big downside in drawing a bright line within your administration and saying nobody in this administration crosses this line. If you lie to a congressional committee, you are gone. You are out. You are dismissed. But for some reason, there was apparently no pushback. And as the Senate Intelligence Committee noted in its report, apparently only a tiny handful of the individuals who engaged in those heinous activities have been disciplined. Most of those people are still working for the United States government, and quite a number of them, according to the report, have been promoted. So that doesn't seem to me like pushback. Maybe there are other areas in which the Obama administration has pushed back. I'm disturbed by, however, the bottom line of Mark Mazzetti's reportage, which is that in dealing in the Situation Room with a request from Langley for approval for additional drone strikes over the objections of his staff, President Obama responded, "The CIA gets what it wants," as though they needed to be told that. So, yes.
So you spoke initially about the lack of legal justification for the CIA torture, but how do you respond to those who claim that 2001 UMAF was that legal justification?
The question is, how do I respond to those who claim that torture was legal because it was authorized by the 2001 AUMF, the AUMF enacted on the 14th of September following the, you notice I didn't myself get into a discussion of the legality of these activities. That's one of the issues that's raised. The authorization that is in question authorized the executive to use force against the perpetrators of the 9/11 attacks. The classic rule of statutory construction is that you give effect to all statutes that bear upon a given subject matter if it is possible to reconcile them. And it seems to me the AUMF is easily reconciled with the various prohibitions against torture. You can use force up to, but not beyond, the line drawn by those statutes that preclude the use of torture.
Thank you.
A question that assumes that perhaps, take for example an American citizen or American institution, if it's injured by the acts of the efficient government that you have described, and if it's within the national security area which operates in secret, where does the injured person go to obtain relief and to stop the injury if it is continuing?
Thank you for asking that question. I appreciate that. I was hoping somebody would give me an opportunity to talk about that part of the book, because a good part of the book does relate to precisely that concern. Let's talk about the courts. You know, this town is now wrapped up in this bizarre discussion of the extent to which the president has authority under existing law, one of the laws being the AUMF that was just asked about, to prosecute the war against ISIS. The interesting thing is, lost my train of thought completely. Oh, the interesting thing is, nobody anywhere in the country has filed a lawsuit challenging what the president is doing. I mean, despite the fact that the legal community and the body of experts, legal experts on this question, look with great skepticism at the claim that these two AUMFs that the White House relies upon, the other one enacted initially to authorize use of force against Iraq, great skepticism about whether these things are available. Nobody anywhere in the country has brought a lawsuit challenging the arguably illegal war against ISIS, illegal until it's authorized by Congress. Illegal because the War Powers Resolution was triggered by the initial use of force on August 7th, and the 60-day time period in the War Powers Resolution expired, therefore, on October 8th. But this seems of no interest to the judiciary. Why has no one brought a lawsuit? Answer: because the courts have essentially gotten out of the business of litigating and trying national security cases. You know, they've developed a series of doctrines that they rely upon to prevent an individual from having his or her day in court. These lawsuits are dismissed before anyone gets an opportunity to argue his or her case on the merits. The political question doctrine, for example, is regularly invoked by the courts in response to efforts by members of Congress to enforce the War Powers Resolution. There's not been a single case in which anybody has been able to get before the courts the merits of a claim that the president's violated the War Powers Resolution. Try litigating a case challenging the secrecy of the CIA's budget on the grounds that the Constitution in the Public Accounts Clause requires the CIA to make public its budget. Answer: that is a action for which no one has standing because there's no individuated injury. And the United States Supreme Court dismissed that particular action on those grounds. Try litigating a challenge to the fact that some members of Congress serve in the Congress at the same time they are members of the military. Sorry, case dismissed, no standing. No one the Supreme Court has said has the individuated injury to press that suit, and as a consequence, vast portions of the United States Constitution are not enforced by the United States judiciary today, notwithstanding the fact that in 1803, Chief Justice John Marshall, speaking for the United States Supreme Court in Marbury against Madison, said it is emphatically the province and duty of the judicial department to say what the law is. It is difficult to find more than 2 or 3 cases in which any plaintiff complaining about even the most serious violation of his or her rights as a consequence of the Bush-Obama counterterrorism policies has even had a day in court, let alone recovered a dime in damages. And I don't want to be too long-winded about this, but I want to give you a final example, and that is the state secrets privilege, under which the courts simply refuse to entertain lawsuits that will result in the revelation of classified information. A German citizen named El-Masri was picked up shortly after 9/11 in Macedonia, right near the border. He was picked up by the Macedonian authorities, brought to the capital, locked in a hotel room for 22 days, and told that if he tried to leave, he would be killed. He was interrogated there, taken from Macedonia to a black site prison in Afghanistan, where he was held for 4 months and brutally tortured. I won't get into the specifics. They are in the Senate Intelligence Committee's torture report. Following this, he was shipped off and dumped in the middle of nowhere in Albania at the side of a dirt road in rural Albania. The thing is, they had the wrong guy. They had misspelled his name. This guy was not affiliated with Al-Qaeda. He had no idea why this was being done to him. So he went to the courts in the United States and sought relief. And his claim was dismissed on the grounds that it would reveal state secrets. He went from there to the European Court of Human Rights in Strasbourg, and he brought essentially the same action. And we know that the facts that I've just related are true because by a 15-0 vote, the court decided in his favor and found those facts after the doors of the American judiciary had been slammed shut for him, as they have been slammed shut for virtually everybody else who has sought relief.
Thank you. Having been the victim of the Socratic method at law school for many years, I'm going to narrow my question and try and sharpen it. Let's remove the foreign element, and let's remove the possible mistakes of what it is, can be construed as war. Let's come back to the United States with an American citizen in the United States. Now, perhaps the judiciary has been co-opted through the act of the Congress creating the FISA courts, which are secret. Otherwise, the court system is still there, but how does a person seeking relief and justice from some illegal act of the efficient government go? How does they do it? Either with the efficient government itself or with the court system. There are two roads of remedy here. Do you have any comment on that?
Well, I'm glad you brought up the FISA court. I mean, I refer to it as a court in quotes. You may be aware of its record. This is the Foreign Intelligence Surveillance Court that was established in 1978 following the revelations of the Church Committee that the National Security Agency in Operation Shamrock had been unlawfully intercepting the phone calls of American citizens and compiling a watch list of civil rights and anti-war activists based on these telephone intercepts. From 1979 to, and the job of this court that was established in response to that was to pass upon warrant requests from the intelligence community to intercept these sorts of phone calls. So domestic surveillance of this sort couldn't be done without individual warrants of the phone calls in question. From 1979 to 2013, the FISA court approved 35,311 warrant requests. It disapproved 12. All the opinions that it issued, approving and disapproving, were classified. It pioneered the development of a new two-tiered system of American law in which there is secret law, known to the Trumanite Network, as I refer to it, and public law, known to the rest of us. We have no idea today what's in most of those. A couple of the opinions have been released, what's in most of those opinions. For the first several years of the court's existence, it didn't even have a courthouse. It met on the 6th floor of the Justice Department in a room down the hallway from the lawyers who argued before it. And there were only lawyers on, and are today, only lawyers on the government side of the case. Nobody gets to appear before the court opposing the government's arguments. Nothing has been done to change that procedure since the Snowden revelations caused public attention to be focused on it. You know, I promised our hostess that we would be timely in getting out of here. So I think there may be a chance for one more very brief question. Thank you very much for those questions. Appreciate that.
I don't know how brief, and I apologize if it's not as relevant to the immediate discussion, but I've found myself, as I'm in the process of reading your book or thinking about national security from a very lay point of view, that I'm looking for some clarification between what I think of, or we term, foreign policy and national security policy. And the reason that comes to my mind is because it seems to me, I get the impression that the Obama administration, or at least Obama, seems to have been approaching what I think of as foreign policy in a different way than the Bush administration had, in terms of not U.S. acting alone, but trying to build partnerships and do things in a multilateral or with other countries, and a different impression of what our role is in this country. And so, anyway, if anything you have to clarify that or help me sort out the differences, or if it's, however it's relevant.
Well, it's clear that the rhetoric has been different, and I don't say that in a demeaning way. I think language is important in diplomacy. That's largely what diplomacy often is. And the optics are important. Sometimes, however, the optics are misleading. You know, I say, for example, in the book, something that may be a little misleading. I say, well, one of the exceptions to what I've been talking about is President Obama ended torture. The torture that was going on in the Bush administration was terminated and doesn't continue in the Obama administration. I guess that's true, but it depends what you mean by terminated. The fact is, months before the end of the Bush administration, as the Senate Intelligence Committee's torture report makes clear, the waterboarding and the other enhanced interrogation techniques had ended. So when President Obama issued an executive order in his first week of office prohibiting torture in most instances, when he issued that executive order, it didn't really have any effect because there was no ongoing torture. And as Dianne Feinstein pointed out, that executive order can be superseded at any time by any subsequent executive order. If you want to, as she also correctly pointed out, give it the force and effect of law, as you know, you got to incorporate it into law so that it can't be superseded by a subsequent inconsistent executive order. So anyway, there are many examples of that sort of thing, but I think we're probably out of time. Again, thank you all so much for coming. I really appreciate it.